Good morning, everyone, and welcome. On behalf of the Philadelphia Bar Association, I welcome you to our Meeting the Moment program, Focus on the Rule of Law. My name is Kathy Jaffari, and I am proud to serve as your Chancellor this year. As our other Meeting the Moment programs, I want to thank the Philadelphia community for showing up for such an important convening. Since 1802, the Philadelphia Bar Association has upheld the values of protecting the rule of law and defending our democracy. Our Meeting of the Moment series of programming helps lift up these values. As we continue to move through 2025, we are finding the power of our voice to stay true to our mission, to serve the profession and the public by promoting justice, professional excellence, and respect for the rule of law. We are trying to do this by creating opportunities like this one for lawyers and the legal profession to work together to meet this moment in service to our democracy. It is a critical time when our justice system is being challenged every day that we all join together to protect access to justice. In doing so, we will support the mission of the Philadelphia Bar Association and the values of lawyers, judges, and the legal profession by fostering the understanding of, involvement in, and equal, unabridged access to our justice system. We've come up with 3 ways that you can lean on our association at this time. First, we are the convener. One of the Bar Association's greatest strengths is that it encompasses legal professionals from across the city, including different practice areas, firm sizes, experience levels. We value the contributions and viewpoints of every member. We are committed to creating tables where we can convene and support each other, just like this one. So let us know what you want to discuss, and we will create the table. Second, we are the communicator. We make our voices heard through resolutions, statements, even amicus briefs. We have spoken out on numerous occasions this year in defense of the rule of law and independence of the legal profession. We have signed on to 4 amicus briefs in protection of legal independence, 3 of which have already been provided relief to the law firm plaintiffs. So we're very proud of this work and what we'll be talking about today. We have made statements in support of judicial independence, which is an imperative, and you will hear from our esteemed panelists on that topic as well. We've also created a web page on our website, so please go to that page of Meeting the Moment to know the law documents, see what area law firms and city legal service agencies are doing. Finally, we're the collaborator. We will collaborate with different partners in disseminating useful information, promoting opportunities to engage in volunteer pro bono work, and it's a reminder to all to donate financially to support the work that you care about. So with that, I welcome you to the 5th in our series of Meeting the Moment in 2025. This one is focused on the rule of law. I am hopeful that the dialogue we have today will help provide us with guidance on what we as lawyers can do to meet this moment and help make a difference in defending our democracy and protecting the rule of law. We have 2 great panels, as I mentioned, the first on the imperative of judicial independence, and the second on how we protect the legal profession and the lawyer's ability to serve their clients. Before we begin the programming, I'd like to extend a sincere thank you to Debbie Gross for all of her help in getting this program off the ground. And of course, Vic Patel, Chair of the Board of Governors, in supporting me with his positive attitude that we could get this done. Finally, thank you to Rachel and Wes from the Bar Association staff for their tireless work in making today's program happen. I'd also love to thank our speakers, whom you will meet shortly. But before we get there, I am so excited and proud to say that we have a video from the president of the American Bar Association, Bill Bay. He extends his apologies that he could not be with us this morning live. As you can imagine, his travel schedule and his movement schedule is jam-packed as he, with the ABA, is working tirelessly to support the rule of law. But when asked if he would speak to our membership, he did not hesitate in a beat. So with that, let's turn it over to the video from Bill Bay.
Good morning. I'm Bill Bay, President of the American Bar Association. Thank you, Chancellor Jaffari, for inviting me to say a few words at this Meeting the Moment program on the rule of law, and the Executive Director of the Philadelphia Bar Association, Harvey Hurdle, as well as our panelists who are going to follow me, and especially to all of you for attending this important program. Thanks for your leadership and commitment to the rule of law, to your communities, to the members and voices that you represent, and for creating this initiative. Meeting the Moment is an apt title for this program and this moment in our history. It is exactly what this bar has done and what we all must continue to do as we face an unprecedented pattern of attacks on the rule of law, judges, lawyers, and the profession. And all of this from elected and appointed officials of our own government. We must meet the moment as government officials have called for the impeachment of judges because they didn't rule in their favor. We must meet the moment as government officials have publicly criticized judges in highly derogatory personal terms that should cause anyone to cringe. Such actions are blatant attempts to intimidate judges. We must never accept such behavior as normal. Instead, we must follow the wise counsel of Chief Justice Roberts from his 2024 year-end report on the federal judiciary. And he said within the past year, we have also seen the need for state and federal bar associations to come to the defense of a federal district judge whose decisions in a high-profile case prompted an elected official to call for her impeachment. Attempts to intimidate judges for their rulings in cases are inappropriate and should be vigorously opposed. These are Justice Roberts' words, not mine. It is a direct call to every lawyer and bar association. But the attacks are not limited to judges. The administration has attacked lawyers and law firms for the legal work they've done or the clients they've represented. Lawyers know this conduct is wrong. Every state Supreme Court has said that a lawyer's representation of a client does not constitute an endorsement of the client's political, economic, social, or moral views or activities. But these attacks are not only attacks on law firms and lawyers, they're attacks on everyone's right to the legal representation of their choice. And they are contrary to the code of ethics adopted by every state Supreme Court. Bar associations throughout the United States and the world, including the Philadelphia Bar Association, have spoken in defense of the rule of law and condemned these actions. Their collective membership measures in the millions. I am so proud that bar associations are not afraid to speak. I am proud of the work that bar associations do to make lawyers better and to serve their communities. It is a growing coalition of the willing. Our profession must stand for what is right, and we must be guided by this key point. There is never a wrong time to stand up for what is right. There will likely be more difficult days, more threats and attacks. But there is one thing you can count on. The American Bar Association and bar associations like yours will continue to stand, speak up, and act. Not because we are against any administration, but because we believe in standing up for the bedrock principles that have served our country for 250 years. The rule of law, due process, our judicial system, and our profession. And the ABA will continue to work to eliminate bias in our courts and profession and to enhance diversity. We are not going to retreat from that. I've yet to hear of any judge who does not believe that our courts should treat everyone fairly and impartially. So does the ABA. And we will continue to have the courage to say so. We need everyone to rally to the cause. We must continue platforms and activities like this Meeting the Moment program. But there is also work each of us can do. Tell your neighbors, those you see at the grocery store or the ball game, those where you worship. Tell them why the rule of law matters. Tell them why due process matters. We have resources you can use. Together, we are stronger. The rule of law is more important than our differences, what your political party or philosophy is, or where you live, or what you do. The fight to preserve our democracy is too important for us to stay silent. Because if the ABA and the Philadelphia Bar and all of us do not speak, who will speak for the organized bar? Who will speak for the judiciary? Who will protect our system of justice? And if we don't speak now, when will we speak? Thank you for speaking. Now is the time for our profession to speak with one voice. Crisis management is important, but crisis leadership is paramount. That is what you will see from the ABA. That is what I see from the Philadelphia Bar. I believe there is power when we stand together. I also believe this is our moment to do what is right, even in the face of difficult circumstances and risks. This can be our finest hour as a profession. Thank you for the opportunity to speak with you on these issues.
I am so grateful that the president of the ABA took time to speak with us today, and I am grateful for what the ABA is doing to protect the rule of law. It's now time for our keynote address, and I am honored to introduce Judge McKee, who was sworn in as a judge of the U.S. Court of Appeals for the Third Circuit on June 20, 1994, and became Chief Judge on May 4, 2010. He served as Chief Judge from 2010 to 2016 and assumed senior status in 2022. He began his legal career at a large Philadelphia law firm, but left there in 1977 to begin his career in public service. He has since been an assistant U.S. attorney, deputy solicitor to the law department of the city of Philadelphia, and general counsel to the Philadelphia Parking Authority. He was elected to a 10-year term as a judge of the Court of Common Pleas for the First Judicial District of Pennsylvania and chaired the Pennsylvania Sentencing Commission. He was appointed to the Court of Appeals by President Clinton shortly after being retained for a second 10-year term on the Court of Common Pleas. Judge McKee serves on the boards of directors of several nonprofit organizations and institutions, including the Vera Institute of Justice and Syracuse University. He is also a member of the Board of Visitors of Temple University Beasley School of Law, an honorary member of the Board of Visitors of Syracuse University College of Law, and has been an advisor to the American Law Institute. He also previously served on the Criminal Law Committee of the United States Judicial Conference. Judge McKee, please join us now.
Kathy, thank you very much for that wonderful introduction. Actually, anytime someone mentions my association with the Philadelphia Bar Association, I'm concerned whenever anyone mentions my association with the Philadelphia Bar Association that I'm going to get hate mail, but we'll see. At the outset, I want to be clear that my remarks today should not be interpreted to reflect any judicial philosophy or political bias. It's simply a reality that no candid discussion of the rule of law can shy away from mentioning current events or the extent to which they challenge the vitality of the system of checks and balances we all learned about in school. Around a decade and a half ago, a mathematical theoretician named Samuel Amberson used a discipline known as cryodynamics to answer the question, how long will America last? The field of cryodynamics, which Amberson used for his historical study, uses mathematics to understand the shape of history. His data set spanned over 3,000 years and was comprised of everything from the Babylonian Empire of ancient Mesopotamia to the Byzantine Empire. He concluded that the average lifetime of these powers was 215 years. As you know, we're about to hit our 250th anniversary, beyond the average lifetime of the average empire. As the title of Dean Erwin Chemerinsky's recent book reminds us, no democracy lasts forever. Nevertheless, columnist Amanda Taub argued in a 2024 article in the New York Times, the United States does not appear vulnerable to democratic collapse. It is one of the most prosperous countries in the world. It has never been a Soviet satellite state or been ruled by a single-party authoritarian regime, such as countries where democracy in the Western sense ended nearly as fast as it began. Taub claims that the US ought to be the paradigmatic example of a consolidated democracy. But she then asks, so how, after all that time, could the American democratic project be coming apart? As Dean Erwin Chemerinsky has observed, the Constitution is revered. Teaching and even popular entertainment has made demagogues of many of the framers, but he cautions that such reverence has kept us from discussing and from focusing on the flaws of the Constitution and how much they contribute to the current crisis in our democracy. He reminds us that the Constitution was created by a small group of men who hashed out a deal in their own interests, chief among them protecting smaller states, slavery, and the interests of slave owners. Thus, the Constitution itself rests upon a foundation of economic and racial inequality, and the framers erected enduring barriers to political equality, including an electoral college that makes minority victory possible in presidential elections and allows 2 senators for each state, regardless of population. As an aside, when I reflected on that observation and on the fact that the framers actually were charged when they went to Philadelphia, not with drafting a new constitution, but reforming the Articles of Confederation, I had this vision in my mind of what people like Madison, the reaction they must have gotten when they went back to their homes after being sent to Philadelphia to reform the Articles of Confederacy, when they reported that, in fact, they had torn up the Articles of Confederacy and formed a new constitution. I couldn't imagine anything other than a greeting such as, wait a minute, you did what? In any event, in their book Partisan Nation, Paul Pearson and Eric Schlicker argue that the effects of the resulting polarization resulting from the structure of government we have, including the Electoral College, has been especially renounced, he says, for Republicans, because Republicans don't need to win in heavily Democratic-leaning states to control the Senate or the presidency. They therefore have less of an incentive to tack to the center in order to appeal to swing voters. Instead, he reminds us, Republican primary contests have often become battles to move furthest to the right. And I would add, the very same is true of Democrats, who no longer need to win in heavily Republican-leaning states. Similarly, driven by advertising dollars and the need to ensure the largest possible audience, programming is aimed at those who constitute a reliable, favorable audience. The result is that media has become so partisan that it has a similar impact on viewers as government-controlled media in countries without meaningful press freedom. Pearson and Schlicker observed that extreme politicians and commentators are rewarded with attention, airtime, and an improved national profile, while those who advocate moderate policies or bipartisan cooperation can be iced out of media coverage and perhaps also iced out of donors' and voters' good graces. Fidelity to the base and fear of one's political base outweighs fidelity to the rule of law that elected officials swear to uphold. Pearson and Schlicker further theorized that one result is that many of the institutions crucial to democracy no longer fully functions. Sure, the United States still has a free press, but voters primarily get their news from the ecosystem, where they won't hear criticism of politicians they agree with or positive assessments of politicians they disagree with and dislike. Thus, there are no more universal truths. Walter Cronkite has been replaced with alternative facts. I submit, therefore, that each faction creates and believes its own reality, and that reality is reinforced on shows that bear more resemblance to infomercials than news broadcasts. It is hard to see how the rule of law can even be accepted as the norm if officials, while in office and after leaving it, refuse to accept the results of elections. Lincoln famously proclaimed that a nation divided against itself cannot stand. I submit that the rule of law cannot long stand in such a house either. Thus, elected officials sworn to uphold the Constitution quite confidently proclaim that the thugs whom we all saw assault police and storm the Capitol were in actuality patriots and victims of a politicized justice system. The level of partisanship is so insidious that the Attorney General of the United States even questions the results of the 2020 election and prioritizes prosecutions and policy accordingly. We may just be living in the divided house that Lincoln doubted could survive. A few years before the 2024 election, Adam Gopnik wrote an article in the New Yorker entitled, "How to Build a 21st Century Tyrant." In it, he summarizes various books that had been written about how those who would attempt to transform democracies actually operate. One of the books he discusses is by Sergei Jurev and Daniel Treisman. It is titled Spin Dictators, The Changing Face of Tyranny in the 21st Century. They argue that the new generation of authoritarians exploit the levers of democracy, but use more discrete forms of manipulation to extend their rule. For example, the new breed of dictators very adeptly use social media. Authoritarian rulers can come to power by democratic means and stay there partly by exploiting fear, intimidating private firms, and I would add, educational institutions. We are all familiar with Shakespeare's statement in Henry VI to the effect that if one wants to destroy the rule of law, the first thing we do is kill all the lawyers. But actually, killing is neither necessary nor convenient. Rather, as Gurev and Treisman suggest, the rule of law can be undermined by an atmosphere of retribution and fear that merely silences all of the lawyers, or at least a critical mass, a sufficient number of them. And we can confidently add educational institutions to the free press to the targets that must be silenced if the rule of law is to be replaced by a modern version of tyranny. The modern tyranny that Gurev and Treisman write about can only arise if the guardrails intended to curtail excesses of power and codes of personality are removed and replaced with people whose primary allegiance is to the person who is the head of state rather than to the state itself. It can emerge when cronyism supplants competence. Many observers argue that is happening even as we speak. Jonathan Rauch writes in the February 24, 25 issue of Atlantic magazine, since coming to power, the government's effectiveness has been reduced because people who lack the skills and temperaments to do the jobs have been appointed to important positions. Mass firings have emptied the civil service of many of its most capable employees. We have seen the defiance of laws that could just as easily have been followed. We have seen the plain language of statutes disregarded along with court rulings and the constitutions, thereby setting up confrontation with the courts. We have also seen the head of state, who took an oath to defend the Constitution of the United States, reply, "I don't know," when asked if he would follow a key and unambiguous constitutional mandate. Regrettably, if you are listening to the swollen outrage or the public condemnation from others who took the same oath, you'll not hear it. It's not there. Contrast this with the Watergate scandal, during which President Nixon's outrageous conduct moved members of his own party to forcefully oppose him and insist upon his resignation, a resignation which soon followed. We are so far removed from that atmosphere of accountability today that observers such as Rouse explain that the current administration is transforming even the nonpartisan, merit-based federal workforce into one that demands and rewards only loyalty to a person, not to any system of laws. This elevates loyalty to the individual president or the oath of office in the best interests of the public. And this is combined with an effort to convert federal employees to at-will employees who would lose civil service protection. I submit, however, there is a glimmer of hope. Kuriev and Treisman ended their book on a defiant note. They remind us, quote, in more developed, highly educational societies, what holds back aspiring spin dictators is the resistance of networks of lawyers, judges, civil servants, journalists, activists, and opposition politicians. They remind us that we have a powerful idea around which we can unite, the idea of what they refer to as liberal democracy and what I believe and refer to as rule of law. I'm hopeful that in today's discussions and in discussions like this that will follow, each of us will dedicate ourselves to doing all that we can ethically do to preserve the rule of law and thereby help this American empire endure for another 250 years. It is the call to action that President Bay refers to. I thank you for your attention and thanks so much for the Thinking and Caring members of the Bar Association, its officers in particular, who are responsible for today's discussions. Thank you.
Judge McKee, thank you so much for your inspiring words. And your words resonate with me. Just this weekend, as I celebrated my 30-year anniversary from law school, we talked about not just the threat of authoritarianism, but perhaps we are already in that state, as you discussed. When there is fear, when speaking out against our government is met with intimidation, when force is used to control, it seems that tyranny has lifted its head. So we will keep your words of hope close as we continue to do our work here at the Philadelphia Bar Association. Thank you so much. Next, it is my pleasure to introduce Debbie Gross and her incredible panel, whom she will introduce. Debbie has been a former chancellor, an excellent chancellor of the Philadelphia Bar Association, and she is currently the president and CEO of Pennsylvania for Modern Courts. Debbie, and with the rest of the panelists, please join us. Over to you.
Thank you, Kathy, very much. I truly appreciate what the Bar Association is doing right now to meet the moment. My introduction to my panel doesn't do it justice. They are esteemed and have resumes and activities and honorariums that I'm not going to go into because of our limits in time. But I want to introduce you to Judge D. Brooks Smith, who is a senior judge for the Third Circuit. He previously, similar to Judge McKee, was the chief judge of the Third Circuit. He has been a steadfast leader and supporter and to the rule of law, the independence of the judiciary. He has chaired the Third Circuit's Judicial Council Committee on Courts, Community, and Rule of Law. He has spoken about the rule of law to many countries, such as Azerbaijan, to Bulgaria, Latvia, Albania, Moldova, Macedonia, Bosnia, and he is, and I thank you so very much for joining us. He was formerly a chief judge of the Western District of Pennsylvania when he was the district court judge. So thank you, Your Honor, for joining us. We also have Judge Cynthia Rufe joining us, who is a senior judge for the United States District Court for the Eastern District of Pennsylvania. She too is a member of the Third Circuit's Judicial Council Courts, Community, and Rule of Law. She also was a past president of the Federal Judges Association. This is a voluntary organization of Article III judges whose mission is to support and enhance the role of its members for fair and impartial independent judiciary, and to sustain our court system of justice through civics education and public outreach. And you will hear all about this, what the Courts Community and Rule Committee has done and what Judge Cynthia Rufe has done as well. Our third panelist is Chip Becker. Chip Becker is a partner at Klein and Spector. He was appointed in December 2022 to serve as a member of the Pennsylvania Court of Judicial Discipline. He is also co-chair of the Supreme Court's of Pennsylvania's Commission on Judicial Independence, and he will speak to their increased efforts and important efforts to educate, to provide civics education and outreach to our community. So thank you all for joining us. Judge Smith, I'm going to pass it off to you. I'm going to ask a question, but feel free to manipulate my question, because what does the meaning of what does judicial independence mean to you as a judge, right? You have these limitations. Once I was with another judge recently who said, once they become a judge, they enter they enter the monastery. So let's talk about what judicial independence means to you.
Well, let me begin by just responding to your characterization of the bench, and I can say especially the appellate bench is the monastery. And I discovered that having been a trial judge for, 18 years on 2 courts. And the only thing I could think to do to counteract that monastic existence was to bring my dog into chambers on a regular basis for company. And it did do some good in that regard. To your substantive question of the notions, the concepts of judicial independence and of the rule of law, the two are necessarily conjoined. And we can't talk about judicial independence without discussing it as being the constant, diligent exercise of judicial responsibilities that are governed by a rule of law. So that is, I think, the best way for us to understand it as judges, as lawyers, and the best way we can message it to the public. And I know that both Judge Rufe will, as I intend to do, talk about what we as judges and as organizations of judges are attempting to do to spread the word, if you will, to attempt to make the public, the citizenry, understand what it is we're doing during these difficult times. So as a kickoff to what are not really prepared remarks, but notes that I've made to be responsive to what our topic is, the judicial independence imperative. And it is just that. It must be an imperative if we are to do our jobs honestly and forthrightly and in a way that engenders public respect. I do think we need to talk about the so-called present age, and my colleague and my genuinely dear friend, as I think Debbie and others know, Judge McKee and I have known each other for a while. We not only work together, but we're good friends. Our wives are friends, and this is the kind of relationship that, quite fortunately, a judiciary can help to foster, and I'm grateful for that. But I don't consider it an extravagant characterization when I say that the judicial institution today faces more and varied challenges, serious challenges, than it has at any time in my, I hate to say this, over 40 years of service on 3 different courts. When I refer to the judicial institution, I'm talking about both the federal and state courts across the U.S. Like Judge Rufe, I too was a Pennsylvania trial court judge decades ago. But in the brief time that we have here, it's the federal judiciary of which I want to speak, although our sisters and brothers on the state courts face many of the same challenges that we federal judges face. We federal judges cherish our decisional independence under Article 3 of the Constitution, as we should. In rule of law work that I did, and you referred to it, in years gone by, in numerous countries, on several continents, I learned about so-called telephone justice, judges who were little more than bureaucrats, and sometimes, often, at the beck and call of political higher-ups. That, thank God, is not our system of justice. Our tripartite system of governance and the deeply rooted doctrine of separation of powers provides for judicial independence. But can constitutional doctrine and tradition guarantee it? And that's, I think, the question we all have to be asking and trying to find answers to today. Perhaps the most compelling reason for spreading the message of judicial independence and its importance to every citizen is an unfortunate public ignorance when it comes to the basic structures of government. I can't count the number of times that I've read of public polling which asks Americans just how many branches of government their Constitution provides for. The results have never painted a really pretty picture. And I've been amused on a number of occasions over the years as a judge when litigants and people with whom I've spoken have referred to the Attorney General as my boss. Good luck with that. Could it be that America's school systems have provided civics teachers decades-long sabbaticals? I don't think so. Or are students and adults simply disinterested? Has the lure of entertainment through streaming and ubiquitous sporting events diverted our attention from the things that really matter? Perhaps Woody Allen got it right when he observed that 90% of life is just showing up. I'd like to think not. Those of us who have taken up the cause of ongoing civics education believe otherwise. All of us can do more. Judge Rufe has been a leader, not only in the Third Circuit, but nationally in various civics education programs, utilizing a variety of curricula. And it's been my privilege to work with her on some of her projects. We both believe that it is critical that our citizens know that our federal judiciary is composed of women and men who make decisions not for political reasons, but in accordance with a rule of law. Judicial independence doesn't mean that judges are free to do as they please. It means that we are free from political pressure and entanglements that could lead us to make decisions for reasons other than what the rule of law demands of us. Yes, Article 3 judges are nominated by U.S. presidents and confirmed by the U.S. Senate. Here we see the workings of the two other branches of government in judicial selection. And sure, they are political institutions, the executive branch and the Senate. But as we have seen so many times, including lately, appointment by a president is no guarantee that a judge who he appointed will rule in his favor if a policy of that president is challenged in court. As you will no doubt recall, 6 or 7 years ago, President Trump labeled a judge who had ruled against his administration as an Obama judge. I was so proud of Chief Justice Roberts when he stated publicly, "We do not have Obama judges or Trump judges, Bush judges or Clinton judges." I conveyed my gratitude to the chief when I next saw him. But we shouldn't just assume that this political pigeonholing of federal judges is a practice of politicians alone. The news media, and I include some in the so-called mainstream media, engage in this practice as well. Too often, accounts of a decision in a high-profile court case include a reference to who appointed the judge or judges. If I thought that my decision-making was a product of determinism, I would have left the bench long ago. There is so much more about the role of courts that the citizenry ought to know about, what courts do and how they do it. And this is, again, where civics education comes in. We don't need to be expecting the public to sit through entire courses on civil procedure, but it would represent a huge boost in public understanding of what we do if people had an appreciation for the critical importance of process in our role as judicial decision makers. The numerous high-profile cases that have made news just this year have resulted in a certain amount of public clamor, as we know, suggesting that courts are somehow meddling in what are really policy matters, properly assigned to other branches of government. For me, such controversies call to mind the simple words of legal scholar Owen Fiss when he wrote years ago, "Courts are not self-starting. Their proceedings must be initiated by some outside agency, some person, not by the courts." So we take cases that are brought to us. We take them. That's our job. We don't initiate them. And one more thing. If news media and others would make more clear to the public that the grant of TROs and even preliminary injunctions are not final decisions on the merits, there might very well be a little better understanding, not only of what courts do, but also why they are doing it, and maybe less public clamor. Next year, 2026, presents for us cause for celebration, the 250th birthday of the Declaration of Independence. Those who bravely signed that document renounced their separation from a king. They rejected monarchical rule. Let's not forget that in their long train of abuses and usurpations listed in the Declaration had been perpetrated by King George. And the signers included these. He has obstructed the administration of justice by refusing his assent to laws for establishing judiciary powers. And they also wrote, he has made judges dependent on his will alone for the tenure of their offices and the amount and payment of their salaries. Those were the words of the signers of the Declaration of Independence, and an expression of several of their grave concerns about King George. What a powerful salvo in the opening battle for a new republic and for judicial independence. And what a great year 2026 should provide for all of us who believe in the rule of law and who believe in civics education. Thanks
Thank
very
you.
much.
Thank you, Your Honor, very much. And civics education is truly important. And Judge Cynthia Rufe, I know you have lots to share and you've done some amazing programs. So thank you very much. You're muted. You are muted.
Thank you for the introduction and for explaining what the FJA is about, its mission. Let me please say thank you to the Philadelphia Bar Association for hosting this event, for putting it together. My message just doubles down on that so articulate delivery of thoughts and hopes and history that you just heard from Judge McKee and Judge Smith. We are so wrapped up in securing more than ever our position in this democracy, our position as judges. And I'm going to start with something that is somewhat historical, but it all leads to the same place. Former Chief Justice William Rehnquist actually said that judicial independence is one of the touchstones of our constitutional system of government. I like to think, he said, that the belief in the wisdom of an independent judiciary is not confined to the judges alone, but is shared by other members of the legal profession and by the public at large. And this quote to me underscores our role in stabilizing society, the judicial branch, and reminds us that our judicial system stands at the center of our democracy. In a nation born of the ideals of justice and equality, judges are honor-bound to decide cases without prejudice or privilege. Every federal judge has taken an oath to affirm this commitment to the fair and equitable administration of justice, irrespective of the person or entity before us. This dedication is the bedrock of the judiciary, the federal and the state judiciary, and our fidelity to the same is central to how we function as a free society. Yet recent shifts in social and civic mores have led to attacks not only on the institution of the judiciary, our courts across the United States, but on the individuals who work every day to uphold the rule of law. Several years ago, the U.S. Marshal Service investigated over 1,000 threats against federal judges. However, these numbers do not include the thousands of threats that go unreported against judges and other professionals who work in our courthouses to support the work the judges do. Defending our civil society must include protection of the judges required to enforce our Constitution and laws. We are bound by oath and honor to perform our work without fear or favor. No one in our court system should have to live in fear for their lives or the lives of their families. Therefore, it is incumbent upon our civic, business, and political leaders of good faith to urge respect for the rule of law and stand with the judiciary against threats to this great and foundational institution. Why? Because the strength of our democracy depends on the public's respect for the rule of law. The public must understand how our government works and have confidence in the work of judges and the judiciary. There has been an alarming increase in verbal and physical attacks on judges by individuals who disagree with the judges' rulings. Some of these attacks are made by elected officials on both sides of the political spectrum and undermine our democracy. Judicial independence is critical to judges' ability to issue judgments and opinions on which the rule of law depends. But physical attacks and verbal threats imperil that independence by attempting to intimidate judges and sowing broad distrust in the judiciary. Judges are ethically prohibited from speaking about the cases assigned to them, and therefore we cannot speak out in our own defense. Judges need champions for justice, stakeholders to properly respond and educate the public. What is this uptick in verbal threats and remarks, which by last count of the marshals was up about 6,000%? No, 6,000 threats, but 400+% from the year 2020, when a disgruntled attorney actually killed the son of one of our colleagues at her front door, in her place, her only child. We've had threats and actual commissions of homicide against other judges too. So have the state courts. And it is never, ever tolerated. But how do you prevent this? I'm not sure that individuals like that can be prevented. But with the uptick in verbal threats and attacks on us, such as the Domino's pizza deliveries to intimidate the judge and their family at the front door, saying we're here and we know who you are and where you are and what the names of your children are, doxing, the United States Marshal Service that is part of the Department of Justice, that is the Attorney General's department, and that's in the executive branch, is assigned to secure our safety. But they are understaffed and under budgeted, as are many of the divisions in our court system. Our judges, some of them need 24/7 protection, and that is severely imperiled with the cuts in the budget over the past many years. It's not just now. So what do we do with these types of recent events? Such as misinformation, statements by public officials, such as judges should be impeached, or when judges egregiously undermine the democratic will of the people, they must be fired or democracy dies. Several judges, 6 as a matter of fact, are the subject currently of impeachment for issuing orders pausing or blocking the implementation of various executive orders. Judges are accused of being radicals or activists, intent on interfering with the president's constitutional authority as head of the executive branch, undermining our system of government and judicial independence. Disagreement with the rulings of federal judges has never been a justified basis for impeachment and removal from office. Judges perform their constitutionally required duty to decide a case that has been assigned to them in which the plaintiffs assert a particular executive order or policy violated their constitutional rights or federal statute. An effort to intimidate a judge on a case like that and deter them from performing their duties is intolerable. There is large misunderstanding of judges' impartiality and belief that judges are partisan and political. I can't even repeat the quote about that radical left lunatic of a judge. I can't because it's so damaging and shouldn't be heard again. This is not limited, as my colleagues have already said, to federal judges. It also impairs the ability of state judges to be perceived as impartial, fair arbiters of the law. The public needs to understand how judges receive assignments within districts and courts, not handpicking them, and then how they do their work. That is why civics education about the judicial process is very important, why some of us have been committed to it for much of our lives, and judges, more than a few, almost everyone, take part in civics ed in one part or another. I just want to repeat that anything we're saying here is permitted by the rules of conduct, as long as we don't talk about particular cases, as long as we don't comment on other judges' cases, as long as we maintain and enforce high standards of conduct and actually stay within what is permitted in the canons, because the federal judges have canons of the code of conduct that provide a judge may engage in extrajudicial activities, including law-related pursuits and civic, charitable, educational, religious, social, financial, and governmental activities, and may speak, write, lecture, and teach on both law-related and non-legal subjects, which is what we try to do. In many of our programs, we appeal to students, their families, schools. In other programs, we appeal to adults. And our Third Circuit Courts and Community Committee has developed what is now a nationally recognized adult civic education civics program in community colleges, trying to reach another segment of society that may not really understand how the Constitution works and what we do. So there's just a few key points, because I don't know where I am on time.
You're getting close.
So I'd like to just say, this is what the Federal Judges Association does focus on, not just pay and benefits. We are not a union. We're 1,100 plus federal judges, Article 3 judges strong. That's our membership, and it grows all the time. And we know by sharing with each other across the country that we do not decide cases based on the precedent that appointed us. Sometimes we decide them in spite of the precedent that appointed us. It is not a factor. It is not the rule of law. And the rule of law was so adequately and so superbly stated by our Chief Justice Roberts. Yes, Judge Smith, I've never been more proud of him when he issued that most recent statement about our processes. When you're not happy with the judge's decision, you appeal it. That is our process. That is the rule of law. Do you know how this stabilizes the country? Do you understand that for true, everyone? Because that's the message that has to go out. If we don't have this rule of law, we are unstable as a society, and then people won't turn to the courts to decide legal problems. They may resort to other means, and that's not what our founders intended. So judges must be free from threats. An independent judiciary protects all of us, and the rule of law keeps us safe. And we need public education, and that is where I will conclude here, because when we do speak out, this matters. When you speak out, you champions of justice out there, you lawyers, you professionals, and other judges. We will promote information that is not designed to misinform and disinform. We will promote how we do things, not how this case was decided, a particular case, but this is our process. And it's worked for many years. This is not the time to let go of our advocacy for democracy, especially in the judiciary. And with that, I thank you very much for this opportunity.
Thank you. And I just want to note that the Third Circuit judges have been wonderful in helping PMC in its monthly civics education programs in middle and high schools. The federal courts have welcomed students to visit, explained. The federal courts have done an essay contest, a video contest. There is an active engagement, not only from the federal court, but from the state court. And so for any attorneys who are interested in helping advocate about the judicial system, please feel free to contact Kathy or me. And this gives me a good lead in to Chip Becker, who is heading up the Supreme Court of Pennsylvania's, it's quite a mouthful, Commission on Judicial Independence. And thank you, Chip, for joining us. And please share what the court is, the state court is now doing. And you're muted. Nope.
There.
Okay.
Now I got it. Okay. So first of all, just do I have about 3 minutes? Is that where we are? Okay, that's fine. So Debbie, thank you. Kathy, thank you, and all of you. I'm really pleased to be here and honored to be on this, or to be part of this conversation with Judge Rufe and Judge Smith, both of whom I just admire so much, along with Judge McKee, whose thoughts I really appreciated and will reflect upon, as we all will. The Commission on Judicial Independence of the Supreme Court of Pennsylvania has actually been around since 2006, and for much of its time was really active, kind of programmatically, doing programs on the role of the courts in civil society or dimensions of constitutional law. For the last 5 years, it fell fallow, as organizations sometimes do, but Chief Justice Todd last year decided to make a series of new appointments and to re-energize the commission, which now has a very robust group of federal and state judges. The federal judges include circuit and district judges. The state judges include trial and appellate judges. There's a variety of academic figures and lawyers from across the state, led by Judge Mary Jane Bowes of the Pennsylvania Superior Court as the chair, and I am her vice chair. So that's kind of the state of play for the commission. And the commission has a lot of things in this new iteration with a lot of energy under Judge Bowes, has a lot of energy around issues like re-energizing or renovating the website, working around, Judge Rufe, to the point you made, issues of judicial security within the Commonwealth of Pennsylvania. There's some thoughts about doing work, with our public television stations to create programming that will be available for viewing by large swaths of the Commonwealth's population or people, curricular development, various programmatic work, opinion pieces. There's all of that stuff that's in play. But I would say that the main thrust right now of what the commission is looking to do is to mobilize, energize, and enable the 1,100 judicial officers in the Commonwealth of Pennsylvania to be present and active in their communities, talking around issues of judicial independence and the rule of law. And the mechanism for that right now is that, for example, actually just in a couple of weeks, the State Trial Judges Convention will take place. Chief Justice Todd will be there, and she will be leading a conversation with our common police court judges, talking about these issues, and not just the importance of the issue, right? Because that's preaching to the choir, but encouraging them to be active in their communities, talking around these issues. Beginning in the fall, I mean, not to get into the weeds, but there is the administrative office has a program for magisterial district judges in Pennsylvania to have, essentially their continuing judicial education credits worked out. And the magisterial judges through that mechanism also will be receiving that message and encouraged to make talking about judicial independence and talking about the rule of law a regular part of their judicial practice, right? So these judicial officers are in every corner of the Commonwealth, and they're political figures, right? They run for election, and that's something that we have strong feelings about. But it is a fact of the matter that this is a group of people who are comfortable being in public groups, being in public spaces, talking to community groups, talking in schools. It's what they do. So I think this is an important initiative and something that I hope will bear fruit. And if I can just briefly return to the idea of judicial independence, and I won't repeat Judge Smith, the points that you made, but I agree entirely that judicial independence is something that's inextricably woven into our understanding of how our government should work. Judicial independence is a central feature of how we effectuate the rule of law in our society, how we function as a healthy constitutional system. It is the mechanism by which the principles of order, liberty manifest themselves in our society. But independence of the judiciary is a sort of abstract concept. And part of what the Commission on Judicial Independence is thinking about is how do we take this abstract idea, how do we take this mechanism that we call judicial independence, this tool by which these larger principles are made real and healthy and meaningful in our society, like the rule of law, our constitutional system, the principle of ordered liberty. How do we bring that home to to people in their communities and in their lives? And the way to do it is the people of the judges themselves. We know to trust the robe is important. The robe is meaningful, but in the end, people trust the robe. They trust the idea of the robe because they trust the people who wear the robe. And what the Commission on Judicial Independence is trying to promote is to get all of our judges and all throughout the Commonwealth to be present in the lives of the community so that people can hear and see and touch and actually feel what it is that these judges do. Because this issue of judicial independence and more broadly the rule of law and ordered liberty and our constitutional system, this has always been an issue in American society. It was not invented in 2024. It will always be an issue in American society. And these are issues of hearts and minds that must be litigated and fought and striven for every day, every week, every month. And what the Commission looks to do is to create a framework for that to happen. I'll finish with the idea of trust that Judge Rufe, you mentioned. Trusting the courts is essential, right? There is no independence. There's no grant of independence without trust. Everyone who's a parent knows that you give your kids independence because you trust them. But in order to trust people, in order to trust this institution, they have to know the institution. And I think that it is vital for everyone who is connected to the judicial institution, but for the judges themselves also to be present in the lives of our communities. And that's something that we can do in Pennsylvania. It's something that I know the federal judges have worked very hard to do, and it's something the Commission is looking to promote.
And so thank you all so very much. I think it's also, and in concluding, I think it's also important to just note that, that civics is not taught to our middle and high school students anymore. There is a law in Pennsylvania, it's called Act 35. It does require it. It has no teeth. So that not only for us talking to lawyers, but educating young people about what judicial independence is, what the rule of law is, will help this process of understanding and informing. So I thank you all so very much for your active participation, engagement, innovation, and I'm going to pass this back to Kathy Jaffari.
Debbie, Judge Smith, Judge Rufe, Chip, thank you so much for sharing your thoughts and for ultimately defending our democracy by protecting the rule of law in all the work that you're doing. As Debbie highlighted, there are great civics programs abound in the Commonwealth, as each individual on this panel talked about. As a reminder, we have an ACE committee at the Philadelphia Bar Association, Advanced Civics Education that's working to gather volunteers to support all of these programs. So please, with the audience, reach out to me or Debbie, and we will get you to the co-chairs of the committee, get you involved in programming. Also, if you have any questions for this esteemed panel, please funnel them to me or Debbie, and we will get them to the right person. I also want to say I am so grateful for all the work with the young people of our society. And also, we should continue the work with the people who are voting. So those who are going to the booths to cast their vote need to understand the civics in the United States as well. So thank you all so much. And now I get to bring on my esteemed panel for the next part of the program, the importance of of independence of the legal profession. And so I'm pleased to introduce first Hayden Johnson, counsel at Protect Democracy, a cross-ideological organization striving to uphold the rule of law and ensure democratic process properly functions. Hayden works on the free expression and right to dissent team, and before that, he worked for years on projects defending free and fair elections. I've had the privilege of working with Hayden and Protect Democracy in support of our profession over the last few months. And Hayden, it really has been an honor. So thank you for being with us today. Our next panelist is actually my partner here at Cozen O'Connor. So I am proud to introduce Tom Wilkinson. Tom is a member of a very important member of our important amicus brief committee and past co-chair of the state civil litigation section, federal practice and appellate practice committees right here at the Philadelphia Bar Association. He is also the past president of the Pennsylvania Bar Association and recently served on the ABA Board of Governors and a member of the ABA House of Delegates. He has authored amicus briefs himself for the Philadelphia, Pennsylvania, and American Bar Association. So as you can see, we have a couple of great folks here to talk about how to protect the legal profession, which I have been doing this for 30 years. I have never seen the attack on the legal profession the way we've seen it the past few months. So we do, at least I believe, speaking on behalf of myself, that it's important to have this conversation. So let me actually start. I'm going to start with you, Hayden. We keep talking about these amicus briefs, the amici briefs. Why don't you first actually share with the audience, what are we talking about? How did they come about? And really, you have a group of lawyers and folks interested in these civic issues. What are the general principles underlying these briefs?
Well, I'll echo the thanks to Kathy and everyone at Philadelphia Bar Association for having me on, and it's a real honor to be with all these very smart and important thinkers in the legal profession. So thank you. Um, so the amicus briefs are on behalf of many leading geographic bar associations representing hundreds of thousands of lawyers across the country in the four lawsuits on behalf of Perkins Coie, Jenner and Block, Wilmer Hale, and Sussman Godfrey in the DC Federal District Court. And the amicus briefs really came about to defend a very basic principle, which is just the independence of the legal profession is really vital to not just the health of our judicial work, but our democratic processes more broadly. The judiciary functions based on a system of adversarial advocacy and party presentation. And if lawyers are not able to go into court to represent, the clients that come to them or to make the right arguments on their behalf, then that system doesn't operate properly. And so the amicus briefs touch on the importance of the independence of the profession in itself and the function that it plays in the judicial process. And it's important to remember that, in a time where there are efforts to isolate people that are perceived as in opposition to this administration, that there is a collective action that, truly bar associations can do more than anybody else to stand for the basic principles of the profession. The executive orders try to make targeted lawyers instruments of the executive branch and coerce them to assess whether their work satisfies what the executive order says are, American interests, and doesn't go on to define what that means. And what that does is pressure lawyers to avoid certain clients or downplay their clients' objectives if there's any, perceived conflicts with what are the administration's priorities. You don't need me to tell you that, as Judge Howe said in the Perkins decision, this sends a chill of blizzard proportions on other law firms, not just the firms that have been specifically targeted, and the downstream harmful effects on pro bono work, work that really depends on the commitment and, generosity of law firm partners and associates. Those downstream effects have been really severe. While these tactics are really unprecedented in our country, as Kathy says, they are straight out of the authoritarian playbook. Autocrats try to isolate their perceived opponents to weaken them. And in particular, as relevant here, they target the legal profession as one of the most important potential checks on the consolidation of power. And so from 1930s Germany to the Bolsheviks in Russia to modern day Hungary and Turkey, the approach is the same: intimidate and coerce the legal profession to streamline the ability to consolidate power. And these briefs, on behalf of Philadelphia Bar Association and others, try to name both all of those problems and say the bar associations will not stand for this kind of thing.
Really helpful to lay that foundation. And I would say once, Protect Democracy, once the executive orders came out, once in those 4 cases, once the filings were made by the law firms, Protect Democracy reached out to large metropolitan, and my guess is you reached out to others, but I can only speak for the Philadelphia Bar Association, so I will share that. Reached out to the metropolitan large bar associations, and we fortunately, as bar associations, have been speaking for a number of months already, beginning January 20th. Actually, even before that, in the fall of 2024, I had reached out to a number of bar associations saying it would be good for us to be working together and connecting with each other. And so it was really through this process of being in collaboration as a profession and having an organization like Protect Democracy reach out to us in a collective that we were able to work together, support each other, review documentation together, and then find a voice together. And with that, I'd like to turn it over to Tom to actually share with Tom, you were at the front lines, because as a non-litigator, I said, well, this is important, and I'm going to turn to the experts, which is Tom, his committee, the amicus committee. So Tom, could you share with the audience kind of what the process was in how we reviewed these amicus briefs, this request to sign on, and really what the intellectual process was in how it was done and why it was so important, since we ultimately did it?
Well, sure. And thank you again for your steadfast support for the core principles of judicial independence, security, and lawyer independence. Our amicus brief committee typically acts on matters before the appellate courts that are broad interest to our members, including questions that reflect established association policy. We frequently joined in amicus briefs with partners like the Pennsylvania Bar Association, the Allegheny County Bar, and these brief requests are ultimately approved by the Board of Governors and the Chancellor. The amicus brief protocol was updated and revamped under Chancellor Mark Zucker, and we have an excellent group of appellate practitioners who scrutinize the requests that come in, or may on their own initiate suggestions based upon what they're reading and seeing by way of high-profile matters. In this case, we were very fortunate to collaborate with Protect Democracy because, as Hayden noted, they were representing a series of metropolitan bars, including Chicago, Boston, New York, LA, and even the Erie County Bar Association, which was interesting. And, because there were a lot of amicus brief interest in the district court challenges, which is unusual. There were amicus briefs from hundreds of law professors, from hundreds of law firms, as well as advocacy groups. But the partnership with Protect Democracy was a perfect fit for the Philadelphia Bar. And as Hayden noted, the focus of the challenges was on First Amendment associational rights. All of the opinions that have issued have primarily focused on First Amendment matters. And obviously we're looking at core principles. Lawyer independence hasn't been subject to attack in anyone's recent memory until over the past 5 months or so. No president had previously entered executive orders like the ones at issue targeting law firms with adverse action. So it seemed to be obviously a matter of great importance to the organized bar and also to the ABA, which is, as you probably have seen, initiated its own lawsuit recently on behalf of its 200,000 plus members.
Just so that we revisited, either Hayden or Tom, what were the bases of the executive orders? What were law firms and lawyers being restricted from doing?
Yes. Well, the executive orders primarily consisted of 4 different features. They terminated the lawyers' security clearances to federal buildings, terminated contracts with those law firms, and threatened termination for government contractors that did business with the law firms. They limited law firm employee access and employee interactions with members of those firms, and refrained from hiring any employees from those firms for government employment. So as the courts reviewed these issues, by the way, we have each of the amicus briefs on the association website. They're very similar in tenor. I might suggest that we also include all of the opinions issued by these judges because they're really interesting reading. Judge Beryl Howell's opinion in the Perkins Coie case is 102 pages, but it's a very good read, and there are a lot of great quotes, including quotes that draw from the Shakespearean playbook that Judge McKee referenced when the phrase was penned, the first thing we do, let's kill all the lawyers. And Judge Howell also referenced John Adams' famous defense of the British soldiers charged with their roles in the Boston Massacre. She stated, quote, "No American president has ever before issued executive orders like the one at issue in this lawsuit targeting a prominent law firm with adverse actions. The case presents an unprecedented attack on the independence of lawyers. If the founding history of this country is any guide, those who stood up in court to vindicate constitutional rights and by doing so serve to promote the rule of law will be the models lauded when this period of American history is written." Judge Leon, interestingly, apparently is known for the use of extensive exclamation points. There are 26 exclamation points, I understand, in his opinion. Quote, "The cornerstone of the American system of justice is an independent judiciary and an independent bar willing to tackle unpopular causes, however daunting. I have concluded this order must be struck down in its entirety as unconstitutional. Indeed, to rule otherwise would be unfaithful to the judgment and vision of the founding fathers." Exclamation point. Under the First Amendment, the 3 features are retaliation for protected expression, unlawful viewpoint discrimination, and interference with the right to petition the government. So all of these opinions went off on those First Amendment challenges. And in addition, two of the judges also focused on Fifth and Sixth Amendment rights. That wasn't necessary in Judge Leon's opinion, but the summary judgments also included determinations under the Fifth and Sixth Amendment, but some differences in the context on the grants of summary judgment.
And thank you for that, Tom. And Hayden, as you kind of reviewed the opinions and the statements in the opinions, I was actually thinking as you were sharing what the executive's orders were doing in terms of, I wrote down instruments of the executive branch, right? And the use of, as Tom just touched on, right, this concept of retaliation and interference, truly fundamental antithesis to our democracy. Can you share a little bit more about that? Because I am wedded in who and what the Philadelphia lawyer is. And it's the story of the Philadelphia lawyer where no one would represent the individual, right, in New York. And it was the Philadelphia lawyer who went to New York to represent the individual. So Hayden, provide some thoughts there, please.
Yes, I think that's exactly right. That those are baseline principles in our profession, that people deserve to have strong legal advocates regardless of their political persuasion, and if that political persuasion is disfavored by a certain administration. Of course, the favoring of administrations changes, and we want the principle to be the same: no targeting of people based on their opposition to what administration is doing. These decisions are just really important defenses of the rule of law. I think it seems so obvious that these firms win and they would fight back, but it cannot be overstated how devastating it would have been if these four firms, took the path of capitulation, or if somehow these courts had upheld any parts of these executive orders. I mean, that would have been really troubling. And, instead we got to the right outcome. And I think the court's rulings send the message to these firms and to other firms and other institutions confronting how to respond to the retaliation and coercion that they face. And that message is, you should fight back because you should win. And we've seen the numerous partners and clients who have left coerced firms for those who defended their principles and represented the firms defending their principles. I think another significant lesson from these executive orders and the successes of these lawsuits and the work that the Philadelphia Bar Association is doing is that you really need collective action to oppose the administration's efforts to isolate and weaken perceived opponents in ways that really undermine the rule of law. So, that work that the Philadelphia Bar Association does to collectively advocate for your members is critical. And same for the ABA's lawsuit that Tom mentioned, that seeks to remove this, cloud of coercion that still hangs over the legal profession, and say, hey, you can't just say that these four firms are free and clear. We need a court to say that this conduct is unlawful, and that firms who have already made deals or are worried about being targeted next and considering making deals are not faced with that impossible choice. And I think there really is an impossible choice for some firms.
I'm glad you highlighted that actually, Hayden, because we at the Philadelphia Bar Association make no judgment of what law firms believe they need to do to protect their organization, to protect their current clients, to protect their staff. And that's why we say at all of the bar associations that have been in the effort of collective action, we say, give us the opportunity to stand for you, to speak for you, to be your voice, and to support you in the work that you need to do in representation of your clients, because you have the right to represent the clients you choose. So I'm really glad you highlighted that. So in the last minute or two, what do we take away? What is the next step? Is there a next step? What
Well,
should we be
yeah,
doing?
I mean,
Tom?
none of these rulings in favor of the law firms have been appealed, notwithstanding the administration's practice of rapidly appealing virtually every adverse ruling that they receive. And that seems to signal the perception on the part of the administration that it would be fruitless to take an appeal, and that perhaps, according to conventional wisdom, that they never really anticipated to win these cases, but the fact that some firms capitulated and made commitments to provide pro bono legal services on matters of interest to the association generated its own effective win, at least in the administration's view. That is, don't appeal, yet prevail is the attitude. And also, of course, the administration was successful in causing many firms to back away from or abandon their DEI policies. So we have to keep fighting the good fight. We anticipate that the Sussman-Godfrey ruling will be forthcoming, and based upon that judge's prior statements and obviously the issuance of the TRO earlier in the case, that it will come out in the same vein as the other three rulings. So we'll look forward to that, and we'll at least have this authority out there, and whether it will or will not cause the administration to be more reticent to target law firms is a question that remains to be seen. And look forward to see how the ABA complaint works out. Obviously presents some interesting standing issues, associational standing, but it's a very well done complaint, as you might expect, because it was prepared by Sussman-Godfrey. The ABA had difficulty drawing on its usual pro bono partners because some of those firms felt intimidated in putting themselves out there and representing the ABA in that challenge. So there's broad-ranging effects and impacts by way of the administration orders, and hopefully with the work of this association and many other partners, we can push back and at least do what we can to ensure that lawyer independence lives on as a core principle of our democracy.
Thank you for that, Tom. Hayden, final words.
Tom said it well. I think it's important to see how this ABA case comes in, but I want to just express my gratitude again to the Philadelphia Bar Association for doing events like this, but for taking a courageous stand on behalf of your members that says no matter what the administration's views, we think it's important to uphold the independence of the bar and the rule of law, and that's a really important thing to do. So thank you for doing that.
Hayden and Tom, thank you so much for spending some time with us this morning in, again, defending our democracy by doing the hard work of protecting the rule of law. With that said, we have come to the end of our program. I want to thank all of our audience for being here with us today. I also want to say to all of you that as we at the Philadelphia Bar Association strives to represent the voices of our members, that we ask you to reach out to us, let us know what you need and how we can be your voice. I am proud to say we have planned our next Meeting the Moment program for July 16th. It is on diversity, equity, and inclusion, and how to uplift and hold strong in those values. And I want to let you know that the Philadelphia Bar Association will not back down. And with that said, we'll close out our program with the following video. Have a wonderful day.
Well, I won't back down. No, I won't back down. And you can stand me up at the gates of hell, but I won't back down. I'm gonna stand my ground. I won't be turned around. And I keep this world from dragging me down. Gonna stand my ground, and I won't back down. Hey, baby, there ain't no easy way out. Hey, I will stand my ground, and I won't back down. Well, I know what's right, and I got just one life. In a world that keeps on pushing me around, but I stand my ground, and I won't back down. Hey, baby, there ain't no easy way out. Hey, I will stand my ground, and I won't back down. Hey, baby, there ain't no easy way out. Hey, I won't